Okay, give me just a second. Hold on. Anna, I just got, do I hit yes or no? I got a script error. Just exit out.
No.
Here, I'll print out a copy for,
I can summarize it. Normally, after I e-file a copy, I email it to the court and copy the court on that. I just didn't get a chance to do it this time.
it's okay. We'll take a look at it real quick. So, sir, are you Calvin Hawkins?
No.
And this is 24 DCCR 1160. Mr. Hawkins.
Pause right here. This is a classic courtroom strategy moment. The judge isn't confused. She's testing the logic of the deal. Bail-jumping cases can look identical on paper, but legally, which file you plead to matters. Enhancements, prior exposure, even sentencing optics. Defense chose the charge with facts that play better emotionally and legally. Smart lawyering, but the judge clearly wants it justified on the record. What do you think? Strategy or just convenience?
Hawkins is charged with unlawful possession of a firearm by a felon. Looks like the bond is currently set at $100,000. There was a court date, March 31st, that Mr. Hawkins did not appear, and so there was a bond forfeiture, and the bond was raised to $100,000 at that time based on that. And then Mr. Macon looks like was hired, filed motions and letter of representation in October. So here is Mr. Macon, the state's. I don't know why it's printed like this. Oh my gosh. No, I mean, I printed two copies and it printed like 1122. It hasn't done that in the past, ever, when I've never seen it do that. It never has done it to me.
Thank you.
Okay, so the state filed a reply to Mr. Macon's motion asking for a bond to be reduced. Let me take a look. Go ahead.
Just by way of summary.
Yeah.
Page 2, it's refers to the defense criminal history, and also on page 2, the very bottom refers to his jail write-ups, and that's essentially the state's, what the state would ask the court to take into consideration if you are so inclined to reduce the defendant's bond. Criminal history, including 4 previous felony convictions, 1 for burglary, a felony theft, a possession of cocaine, and a felony marijuana. And he's been also written up by jail staff for possessing contraband in jail and failing to follow and disrespecting the rules of staff in the jail.
All right, thank you, Mr. Coleman. And I am getting a copies of any jail incident reports.
I've attached a couple of those reports to my motion. For my reply.
Oh, okay, I see those. Would you check and see if there's anything since December 3rd, please?
Yeah, ma'am.
Okay. So the prior, all of those offenses, the burglary, theft, possession of cocaine, and felony possession of marijuana, all of those are felony offenses and convictions, correct?
That's my understanding.
Mr. Macon, you may proceed.
Yes, Your Honor. First off, Mr. Hawkins, you're unable to make the $100,000.
Hold on just a second. Raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead. I'm sorry, Mr. Macon.
Could you state your name, please? And you've been unable to make the $100,000 bond, correct?
Yes.
Okay, do you have family and friends that were a reasonable bond be set that you could make?
Yes.
Okay, now you understand you're from Florida, so if you make a bond, you'd have to stay in Jefferson County.
Yes.
And you have friends that you would live with here in this area?
Yes, sir.
Okay. Now, you turned yourself in once you learned there was a warrant for your arrest, didn't you?
I didn't know I had a warrant for my arrest, but
But when you learned, you turned yourself in.
yes.
Okay. You understand that you also would be required to wear a GPS monitor and probably a drug patch or anything like that. You comply with all those conditions. And whatever other conditions you were given, you would do. Okay, now with respect to this contraband, the September 26th, they were Tylenol pills, right?
Yes. I just didn't take it.
You were given them by the jail staff and didn't take them. Then December 3rd, and December 3rd incident was you having your jumper down or something.
Oh, man.
But you didn't have a knife or anything like that or anything like that. In other words, they wrote you up for refusal to follow written or oral directives. But you didn't jump anyone or beat them up or anything like that.
No, I don't even recall that write-up. I didn't know it.
Okay. I have nothing further on.
Okay, I'm reviewing the probable cause as well. Give me just a second.
Your Honor, I could ask some questions.
I need to read the probable cause. If you'll just give me a minute, please.
This is where the courtroom temperature changes. Victim statements aren't about proving guilt, they're about impact. And here, the victim is also the husband, which complicates everything. Addiction, theft, fear, compassion, all colliding in one statement. Judges take this seriously, especially when public safety and no contact orders are on the table. Question for you. Should addiction weigh more toward treatment or accountability?
Is there anything else, Mr. Macon?
Your Honor, Damish, and I'm probably mispronouncing this. Damishi, is that how you pronounce that? Demisha Jones is a witness who's going to say the gun was hers and she put it under the seat.
It's not what she told the officers that day.
And that's what she's going to testify to anyway.
Okay. So for the record, I have reviewed the probable cause affidavit. I also did receive notification, and if anyone has questions for the bondsman's representative is here today. And her company had to hire a bounty hunter to locate and get Mr. Hawkins after that bond forfeiture. So obviously, to me, that would indicate that he was not keeping up with his bondsman, and otherwise he would have. If you bond out, you got a bondsman. You check in once a week. You would know you have a court date. If you miss a court date, you would know there's warrant. So there's that issue as well. Mr. Coleman, what's the state's position?
So the only thing I add, Judge, is that he's subject to a habitual offender enhancement, making him $25.99, Judge.
Okay. At this time, based on the nature of the offense itself, the unlawful possession of a firearm by a felon, the probable cause affidavit, and the information that was in that, there were 3 vape pens found as well. I know obviously none of this is proven, but it is important to know. Everybody had different opinions, or the 2 of them, about where the gun was, whose it was. They both said it wasn't theirs. And the fact that he missed court and had a bondsman, and that bondsman had to get a bounty hunter to get him back here, and the fact that he's from Florida, was apparently working supposedly in Louisiana and driving through here to sightsee in Houston when he was arrested, gives me concern about all of that. And so at this time, I'm going to deny the motion to reduce the bond. The bond will remain at $100,000. I'll reset the case for an announcement, and we'll get it moving in whatever direction it needs to at that time. All right.
I was just wanting to say I was never arrested whenever she pulled me over. I wasn't arrested at all.
When?
When she initiated the pullover.
But you had a bondsman, so at some point.
That was after I had found out I had a warrant.
Right.
And I was keeping up with my bondsman. I texted her and said I was trying to.
Here's the thing, she's here, so be careful what you say. I've already made my ruling. You can go back with the bailiff. Okay, thank you, Mr. Rojas. Good morning. Are you Heriberto Chavez?
Yes.
And in cause number 25, DCCR 0559, Mr. Chavez is charged with deadly conduct, discharging a firearm from May 8th of 2025. What is the announcement?
We signed a rejection.
Oh, I'm sorry. Mr. Chavez, what that means is that if you go to trial and you're found guilty, the range of punishment is a minimum of 2 years up to 10 years in prison. Do you understand?
He understands, Judge. He thinks the offer is too high right now.
So the state, I have on the computer tablet a plea bargain rejection that has your signature on it, that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, for a 6-year term in prison. It says or, but.
I think we've been discussing a possible cap, Judge. I think that's
Okay.
just
Just the 6 years.
Oh, today was an offer of 6 or the cap, so it was my
What was the
understanding.
cap of what? Y'all
Oh,
told
You
me?
didn't write it down.
I'm sorry, it should be 8.
Or a cap of 8 years in prison, which is where you would leave your punishment up to me. I could not give you more than 8. I could give you 8 years. I could give you less. You have an absolute right to have a jury determine if you're guilty or not, and for that jury to determine your punishment if you're found guilty. I want to make sure you understand what the possible consequences are if you go to trial, and what your options are if you wanted to enter a plea of guilty. And do you understand all of that? Do you have a question?
I want to try, but I don't want to accept the offer right now.
Mr. Nichols, is there any reason to believe that the state's offer would change?
No, Your Honor.
And here's the twist. The deal hits a wall. Even with a joint recommendation, the judge is not bound by it. And this is the moment defendants often underestimate. The court is saying, time served isn't enough oversight. Probation isn't mercy, it's control. This judge is balancing belief in rehabilitation with fear of relapse. Do you agree with this call, or should the court have honored the original deal?
So you don't have to like the offer, but the offer is what it is. So your option is either to let a jury decide or to accept that offer. And so what do you want to do?
Wait.
There's no waiting. You have to make that decision today. All right, I want to make sure you understand that after today, I won't accept that plea agreement. And do you understand that? Answer out loud.
Yes, after today, you won't accept that agreement.
Okay. Mr. Chavez will get your case set for trial. Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney who could begin preparation for trial quicker. Is that okay with you?
Yes.
All right, so Mr. Rojas, you're released. Mr. Chavez, we will appoint someone today. They should be out to see you very soon to begin preparation for trial. You can go back with the bailiff. Good morning, are you Lee Coney?
Yes, ma'am.
And Ms. Coney, you've got two cases. One you're on probation for in cause number 24, DCCR 1600, on probation for theft of property with previous convictions. There's a new indictment that's been handed down in cause number 25, DCCR 1274. You're charged with possession of a controlled substance, also a state jail felony. It's my understanding that there is no agreement in either of these cases. Is that correct?
That's correct, Your Honor. I was speaking with Ms. Coney this morning and yesterday, and she has a request to make of the court. She would like to have a new attorney.
Well, Ms. Coney, you don't get to pick a new attorney. Mr. Rojas is an excellent attorney. He's, I'm sure, talked with the assistant district attorney, is giving you that information and advising you. And so if you want to take some agreement, that's fine. If not, what's going to happen is today we'll go through that motion to revoke your probation. And I'll get pleas of either true or not true to those allegations. Then we'll reset that case for a sentencing hearing. I'll determine if you violated your probation. If I determine you have, I can either continue you, I can revoke you, I can do whatever at that point. And then depending on what happens on that case, I guess we'll see what happens on that new offense. And so do you want to talk to Mr. Rojas about that agreement, or do you want to go forward and leave it all up to me on your motion, I guess?
I plan to go forward.
With what? Just pleading open to the court?
Yes, ma'am.
Raise your right hand the best you can, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes,
Thank you. Will she waive the formal reading of the motion?
She will, Your Honor.
Ms. Coney, in 24 DCCR 1600, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 29th of 2024 for the state jail felony offense of theft of property with previous convictions, and that was a 5-year deferred probation. Is that correct?
yes.
The motion alleges that you violated your probation. Count 1 alleges that you committed the new offense of possession of a controlled substance, a state jail felony, November 1st of 2025. And is that true or not true?
Not true.
Count 2 alleges that you committed the offense of possession of a controlled substance, penalty group 3, and I'm guessing that's a misdemeanor
I
offense?
think so, Judge. The case is not yet, that case has not been filed.
Okay.
It's awaiting testing right now. It's in progress.
Okay. And I'm not sure if that's a misdemeanor or not then. Penalty group 3, less than 28 grams on November 1st of 2025. And is that true or not true?
I'm sorry, what was it?
It's the same date, it's just a different drug. November 1st of 2025, when you were arrested, it was for possession of 2 different types of drugs.
No, ma'am. No,
Okay,
it's
so not true to count 2. Count 3 alleges that you failed to report to the probation department July 24th, August 21st, October 8th, and October 29th of 2025. And is that true or not true?
I'm listening. He was trying to tell me something while you were talking.
So count 3 alleges that you failed to report to the probation department on July 24th, August 21st, October 8th, and October 29th of 2025.
That's true.
Okay. Count 4 alleges that you failed to never become intoxicated or under the influence of any intoxicating substance. Mr. Nichols, did you read that one?
Failed to never become intoxicated or be under the influence of any intoxicating substance.
And that on or about
March,
the March 19th, 2020.
I'll just drop 4, Judge.
Do you want to, I mean,
This isn't my file, I don't know the details
Well,
of the
let's don't-
violations, and I can't amend right now.
okay.
I don't know what,
What I'm going to do is, at this time, I don't want it I want to know whatever allegation that is at the appropriate
I
time.
can see it here, Judge, and I can orally amend that. What it's supposed to allege is that she tested positive for cocaine on March 19th, 2025.
So any objection to the amendment reading in that on or about March 19th, 2025, the defendant tested positive for cocaine? Mr. Rojas?
No objection.
So count 4 alleges that you failed to never become intoxicated or be under the influence of any intoxicating substance, and that you tested positive for cocaine March 19th of 2025. And is that true or not true? Count 5 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
I'm not.
Count 6 alleges that you failed to submit to alcohol and/or drug screening on July 29th of 2025 at the direction of your probation officer. Is that true or not true?
It's true.
Okay, you'll get to explain later. Right now, just true or not true. Count 7 alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true? I'm sorry?
Yeah, true.
And then count 8 alleges that you are behind in your court-assessed fees as of November 3rd of 2025 in the amount of $575. And is that true or not true?
As of November. On that day, we know.
Yes, that's true.
Okay. Did you enter your pleas of true to counts 3, 4, 6, 7, and 8 freely and voluntarily? And did you plead true to those counts because they're actually true?
Well, with the payment, that my payment is caught up now.
Okay, I'll just take off number 8 and put not true on that one. So 3, 4, 6, and 7, did you plead true, again, freely and voluntarily?
Yes,
And because those counts are actually true?
yes.
All right, then I'm going to find counts 3, 4, 6, and 7 true. Find that you entered those pleas freely and voluntarily. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset the case for a hearing. I would anticipate, Mr. Nichols, that you would have some evidence with regard to the count 1, the new
Yes, Your Honor, the
offense.
state will prove up.
Do you think we would need
I would-
more than an hour or
I
so?
wouldn't think so, Judge.
Okay.
Appears to be a traffic stop.
One or two, I guess, a 2 witness.
Yes.
We need
At least
lab.
2. Hour and a half, I would think.
Okay, we'll get it set for an appropriate day. Just everybody make a notation that it will be set for a hearing for that. Anything that you think is important for me to know, get that information to Mr. Rojas, and he'll present it to me on your behalf when we come back. And if I can get an updated pre-sentence report, that would be great as well. Thank you, ma'am, for being here. You can go back with the bailiff. Oh, actually, come over here to the Clerk, she needs your fingerprint before you go back with the bailiff.